Thank you. Welcome to the third annual Executive's Guide to Patent Strategy, sponsored by, as you heard, the University of Haifa in coordination with Finnegan. We're the largest intellectual property law firm in the world. Every year, our lawyers come from the United States and from Europe to teach at the University of Haifa. And when they teach, they spend their Tuesday nights here in Herzliya giving guidance and advice to Israeli companies on how you can use patents to further your businesses. This year's seminar series theme is IP monetization, licensing, and due diligence. And you heard, if you weren't here, I know there are a number of people who weren't here for the last 2 weeks. If you weren't here 2 weeks ago, we had Greg Gramanopoulos here from the States. He's the guy who just did the big AOL Microsoft deal, a $1 billion transaction, all about IP. He started working on it 3.5 years ago and closed the deal about 3 months ago. Last week you heard from Jeff Berkowitz, who talked about the secrets that companies use to get others to pay money for IP. Next week, if you come, and I encourage you to come, you'll hear from an international licensing expert, Bill Pratt, who's coming from the States, to talk about how to structure IP licensing deals. And the following week, the last week of the series, you'll hear from Laura Mazerovsky. Laura was a prosecutor at the Department of Justice in Washington, D.C. She now prosecutes patents in court. And she's going to talk about how you use the leverage of patent litigation in a cost-effective way to achieve your licensing goals. Tonight, our topic is IP due diligence. How do you know whether the IP that your company is buying or selling is valuable? And I'm really honored to have with me tonight Dr. Stephen O'Connor. Steve is my partner. Steve's my law partner in the Washington, D.C. area. He's teaching at Haifa this week. And he spent most of his career, in the last 15 years of it at least, as an IP specialist. He received a law degree. Before that, he received his PhD in microbiology. And he works with pharmaceutical companies and biopharma companies around the world to help them enforce their patents, to help them defend against charges of infringement, to help them develop patent strategies that increase the value of their companies, and to help them through difficult IP due diligence transactions. By way of introduction, my name is Gerson Panich. I lead Finnegan's Israel practice. I joined Finnegan 24 years ago after completing an engineering degree and then a law degree. And I've spent most of my career in court litigating patents on behalf of companies in the United States, either defending them when they're accused of infringement or asserting patents on their behalf. I've also spent a lot of time doing strategic patent planning for companies, and I do an awful lot of that in Israel, helping companies not just receive patents, but developing a patent portfolio that's going to actually advance the company's business interests. And finally, I do a lot of IP due diligence, which is the subject of our topic of our lecture this evening. So let's get started. I'll speak for the first half, and then Steve will jump in and cover the second half. So when we talk about a company's IP position, we're really talking about two things, right? We're talking about an offense and a defense. It's just like a football team, right? You can't have a good football team if you only concentrate on scoring goals, but you're not looking behind you to make sure that nobody is scoring on you. And it's the same thing with patents. You want to be able to develop patents that block the competition from competing with you, that block the competition from taking your revenue streams. But if that's all you look at, then you're also in trouble, because you might end up stepping on somebody else's patent, infringing their patent, and not being able to proceed with your own business goals. And therefore, you need to have this dual focus when you're thinking about IP in a company. This evening, I'll be speaking about the first, the offensive, and Steve will be speaking about the defensive. Now, when we think about IP, you have to recognize how important it really is to your companies. I mean, most of you are executives in Israeli companies, and I don't know if you've ever thought about how much value of your company is really tied up in intellectual property. But this is a very interesting study that was done by Ocean Tomo, surveying the value of the S&P 500 over the last 40 years or so, from 1975 to the present. And what's interesting, this is just a summary of their results, but what they found was that in 1975, when we were a lot less tech than we are today, the value of the S&P 500 was basically, or I should say the intangible assets of the S&P 500 made up about 17% of the total S&P 500's value. You'll see how that's increased significantly up till 2005 and 2010. 80% of the value of the S&P 500 is made up of intangible assets. Okay, now, intangible assets include lots of things. It includes your trade name, it includes your trade secrets, it may include copyrights, trademarks, but a significant portion of that is patents. Okay? And you think about why it is. I mean, we're in an idea economy now. And the fact is that anybody who develops an idea is this close to losing the value of their business if someone of significance steps in and just takes the idea. And the only thing that levels the playing field, is intellectual property that blocks that competitor from taking your business, from taking your revenue from you. And you look at, it's hard to read the slide, but if you see Microsoft, for example, and Merck, these are companies where it's been reported that their value their intangible asset value is in the mid-90s. Okay? And I would argue that it's the same for Israeli companies, where really the value of your company is tied up in the ideas that really exist within your heads. I mean, the fact is, nobody's going to be interested in buying your company because of capital that you might have in the company, or because of channels of trade that you've established that others don't have, because a lot of the companies here, at least the early stage companies, are R&D companies. And so, there's a quote that I just love by a VC that I lectured with a few years ago, and he made the following comment that I repeat often, which is, if you're not going to invest in the IP, don't bother investing in the R&D, because others will just copy it from you. So let's look at a troubling tale. This is an Israeli company. The names are not revealed to protect the innocent. But this is an Israeli company who is a leader in its field. Okay? Not only is it a leader in its field, but it created the field. There was no technology like this before. They have 50 patents. They have an IP manager that works with them. And yet today, there are a whole series of companies that have grown up after them that are copying them. Dozens of companies around the world are copying them. And when we look at their patent portfolio, there's very little in that portfolio that can be used to stop the competition. And the question is, how can that happen? How can it happen that a company is the first, it develops 50 patents, and it can't stop the competition? And here's another story. Well, I guess first let me answer the question. In part, it's because there wasn't enough analysis done early on, and when the analysis was finally done, it was too late. The time had expired. Here's another problem. This is a company that I worked with that came to me to defend them in a patent infringement lawsuit. What was the story? About a year before they were sued, they acquired a smaller company. And in the process of acquiring that company, they acquired a product line, they acquired patents associated with it, and when they launched that product, less than a year later, they got sued for patent infringement. They did due diligence at the time of the transaction, but nobody found the problem. Nobody saw that there was a problem. And when we got into it, the first thing I said was, well, let's get some leverage here. Let's take some of the patents that you acquired, and let's use those patents affirmatively against your competitors suing you. Will they sue us? We'll sue them back. We looked at the portfolio. There were no patents in the portfolio that would stop the competitor. Not only that, when we look closely, the patents that were in the portfolio didn't even cover our client's own product. How can that happen? It happens because there is a mismatch that occurs between the patents in companies' portfolios and the business goals of the company. And when that mismatch occurs, a very unique thing happens. And it's actually not so unique because I see it over and over again. You see the business going one way, and you see the patents going the other way, and there's no bridge between them. And in a due diligence situation, if you don't look at what the business goals are, and try to see if the business goals are being achieved by the patents, you'll miss it as well. And that's what happened in this due diligence. The attorneys who were involved did what they were asked to do. They were asked, Does the company that we're acquiring own these patents? They said, yeah, they own them. Has anybody ever challenged the validity of these patents? No, nobody's challenged the validity. Have the maintenance fees been paid? Are the patents enforced? Yes, the patents are enforced. Does the description in the patent generally align with the description of what the company does? Yes, it does. But a perfectly valid, enforceable patent that has a beautiful gold seal and a red ribbon does not mean that it's valuable. All patents are not created equal. And the question is, how do you determine whether or not you've got a good patent or a bad patent? And that's what we're going to talk about tonight. Now, the way you start going wrong is you start with a more of a superficial analysis, and you don't really dig deep. And digging deep requires a number of things. Now, what we're going to do tonight, I'm going to try something new. We're going to actually do an exercise and involve the audience. Okay? Because in order to understand the value of patents, you need to really understand what a patent claim is and how a patent claim operates. Now, this stuff tends to be very thick, and people don't like to talk, usually executives don't like to talk about patent claims because it's a big mystery to them. It's gobbledygook. But the fact is, if you don't understand how patent claims work, you're missing the boat. As an executive of a company, you need to understand the claims that your company is pursuing. You need to understand the claims that your company is getting, and you need to be able to articulate how those patent claims are furthering your company's business. And if you can't do that, then something is wrong in your company. That's my view, at least. Now, every patent has three parts, right? You have the drawings. You see, this is just one of them. You have a description, and then you have claims that are at the end of the patent. There's these numbered paragraphs at the end, and those claims define the boundaries of the invention. And there's a great quote from one very famous US judge, and she said, "The name of the game is the claim." All right? The name of the game is the claim because the claim is the foundation upon which your patent rests. Now, just because you have claims that look good doesn't mean that you're out of the woods. But if you don't have claims that look good, you've got a problem. So we're going to take a look at an example tonight. And in order to do this, you're going to need to suspend reality a bit, okay? Come with me back in time. Accept my assumptions. Don't fight my assumptions, otherwise you're not going to get value out of this. Just accept this. We're going to go back in time to a time before the wristwatch was invented. All right? Are you ready to come with me? Okay, very good. At that time, this is what existed. I'm telling you this is what existed, okay? You had a pocket watch, you had a belt with a buckle on it, and you had various forms of wristwear, leather bracelets, okay? So that's the entire scope of the relevant prior art to this program that we're going to talk about, okay? Everybody got it? Good. All right. So, your company invents this wonderful invention. You're calling it a wristwatch, okay? And what does it have? It has a timepiece, right? And the timepiece has two hands. And the timepiece has a glass cap that covers the hands to protect them. And there's a strap, a leather strap, that connects to the timepiece through two pins. And there's a buckle back here that allows you to secure the leather band to your wrist. Okay? That's the invention. This is actually an exercise that we use with our students at Haifa 3 weeks ago, okay? And we asked them to draft a patent claim that covers this invention in the most valuable way they could think of, all right? And now I'm going to show you the results of one of our better students in the class, okay? And I want you to take a look at the claim and give me your feedback on it, and I'll ask you for a vote, all right? So here's the claim that one of our top students wrote. A device, by the way, this is the way claims are written. It's sort of there's no period in this whole sentence until the very end. That's sort of the structure of a claim. So this claim has two elements, as you see, this one and this one. So it's a device comprising a timepiece having first and second hands and a glass cap covering the hands, and a leather strap connected to the timepiece and having a buckle for securing the timepiece to the wrist of a wearer. Now, everybody can, I'm sure everybody's got critiques. We're not going to have a discussion. I'm only going to ask for a vote. Everybody can have a critique and can tweak it a little bit here or there. I want to ask you if you generally agree that this is a pretty valuable claim to have, and you would be happy if this was the broadest scope of your protection? People, raise your hands. I got a no. I got one yes. How many other yeses do I have? Let's see, I want to see the yeses. Okay, I got a yes, 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 yes. Okay. All right? Now, I don't think this is a very good claim. I think a lot of you who are familiar with patents understand why, but let's take a look. It says a glass cap, okay? A glass cap covering the hands. Now, did you think about this? What if somebody were to use plastic? Now, you might say, well, wait, back at that time, there was no plastic. Okay, but there was crystal, right? And there were other transparent materials. By putting glass in the claim, you've taken a claim that would otherwise be very valuable, perhaps, and given your competitors a roadmap on how to avoid the claim. All they have to do is say, fine, I won't use glass. I won't use glass, I'll use a different material. No infringement. That's called the all elements rule in the United States. The all elements rule says if you can avoid an element, or if you can avoid a limitation in the claims, then you don't infringe the claims. Okay? So your competitor could take this whole invention, change out one thing, and they're done. But there's more. It says a leather strap. Why does it have to be leather? It could be cloth, it could be metal, it could be twine, it could be any other material other than leather. By putting leather in the claim, you've given your competitors a roadmap on how to avoid infringing your claim. But there's more. What about buckle? Does it have to be a buckle? My watch doesn't have a buckle, it has a clasp. There are lots of ways that I can connect. I think I could use elastic. I don't even have to have any kind of securing mechanism. By putting a buckle in the claim, you give your competitors a roadmap on how to avoid infringing your patent. And there's even more. Did anyone think of this? Anybody want to yell one out?
Digital.
Hands! Excellent. Hands. First and second hands. There are lots of different ways, even back then, that you could think of things that move that would be able to keep time that wouldn't be hands. Right? Now, let's analyze how we got to the... Oh, so let's take a look at what a better claim would look like. Let's scratch out the hands, let's scratch out the glass, let's scratch out the leather, let's scratch out the buckle, and what we're left with is a device comprising a timepiece and a bracelet connected to the timepiece for securing the timepiece to a wrist of a wearer. Okay? Now, how did we get to that claim? Let's analyze the process that we went through. This is a very simple example, right? But when you're working in your companies, your technology is much more complex. But the principles are about the same. So let's think about this. First, we understood the prior art. We knew where the boundaries were. We knew how far we could push. If I just said something flexible connected to a timepiece, that would not have been sufficient because we already had pocket watches that had flexible chains connected to them, right? So I need to understand where the boundaries are, because if I don't, I'm going to write a claim that's broad, that's going to encompass the prior art and get me no value, okay? We took the time to appreciate really where the invention lies, you know? Is it in the hands? Is it in the glass? Is it in the mechanism? No, we understood that the distinction between the invention and the prior art was the ability to strap it to a wrist. So we understood what the invention meant. Now, this is simple, but in your businesses, it's a lot more complex to really understand where the invention lies. We weren't blinded by the inventor's preferences. Inventors are going to give you invention disclosures with lots and lots of detail in it that are completely irrelevant to the breadth of your invention. And the unskilled patent attorney or the unskilled practitioner is going to throw all that stuff in the claim, or at least one or two elements that are greater than what needs to be in the claim. We considered how, in the back of our minds, we were considering how is a competitor going to try to design around this. They might use crystal. They might use metal bands, right? They might not use hands. And we aligned the claims with the company's business goals and its strategy. We understood, or at least we thought we understood, what the company's goals were basically to sell wristwatches. Okay? Now let's see how this changes if we didn't completely appreciate the company's goals. Let's assume for a minute that the mechanism inside the watch was very precise. In fact, up until this point in time, I didn't share this fact with you, but up until this point in time, watches lost 5 minutes a day because the mechanisms were not very good. And the mechanism in our watch loses only a second a day, and it's cheaper. Now, if the company's goal is to sell timepieces, wall clocks, shelf clocks, watches, wristwatches, pocket watches with this new mechanism in it, how valuable is the claim that we just looked at? It's not valuable at all, right? If in the process of making this invention, the inventors recognized that there were new processes for forming metal to make buckles, and it used to cost 38 cents to make a buckle, and now we can make a buckle for 3 cents, and it has implications for forming metal across all industries, not just for buckles, and that's going to be how we grow our company. How valuable is the claim that we just looked at? It's not valuable, right? It's not valuable to the company's business goals. The point I'm trying to make here is simple. You need to understand what the goals of the company are before you can decide what the protection is that the company needs. And if you miss those goals, you can really miss the boat. So now that we understand this, now let's talk about IP due diligence. Because it's really the same thing. Let me just interrupt. We're not going to take questions during the lecture, but we will afterwards. Okay? So now that we understand how claims operate and the importance of understanding business goals, let's talk about IP due diligence. Because really the same principles apply when you're deciding whether or not you should buy a company's patents, or when you're deciding whether or not a company's patents are valuable or not valuable. One thing to keep in mind is that every deal is different. Every IP transaction is different. And the reason that they're different is because every company wants to achieve different goals with an IP transaction. Okay? These are different reasons why companies enter into IP transactions. And you probably could think of more. You might want to grow your market share by acquiring a competitor. Right now, I have 20% of the market. My competitor, my closest competitor, has 10%. If I can buy that competitor, I now have 30% of the market. So that could drive my sale. The target might have a complementary product line. I sell styrofoam cups. I don't sell lids. My target sells lids. If I could sell lids and cups, I could make more sales, and they're complementary. Those are sometimes called convoyed sales. I might want to buy a competitor's company or their patents because it's complementary technology, and I might want to mash it up into my technology. I have my own products that I sell, but if I could add a feature, adding that feature will make my product sell better. And the company that I'm targeting has that feature already in their products, and I want to add it to my product. Sometimes you buy IP because you're worried about infringing the target's patents. And sometimes you say, you know what? It's better just to buy the company than to worry about getting sued for patent infringement. Because the company is relatively cheap if you think about what the damages sometimes for a patent infringement lawsuit could be. Sometimes you buy IP to obtain patents to sue a competitor. Best example of that is just this past year when Google purchased Motorola Mobility for a record sum of $12.5 billion in order to acquire 17,000 patents. Why did it do that? Because it's involved in major patent wars in the United States. There are about 100 companies in the US suing each other right now. And Google was behind the 8 ball because it didn't start patenting early enough. So it started to acquire patents. Another reason why you would be interested in acquiring a company is because you want things other than patents, non-tangible assets, or tangible assets. And I was in a situation recently. Steve, how am I doing on time? Minus 8.5? Oh, 8.5 minutes left. Great. I can finish this in 8.5 minutes. All right. So here's a situation. True story. About 8 months ago, I was at a company here in Israel working with them, and the CEO grabbed me, took me aside, and said, just want you to know, Gershon, that we are thinking of acquiring one of our competitors. And we're in advanced talks, and just want you to know that. And I said, like any good lawyer, oh, that means you probably need my services, right? Because you want to do due diligence. And he said, no, we're not really buying the company for patents. And I said, yeah, but you still, I mean, whenever you acquire, you got to make sure, you got to do freedom to operate and all. He said, if we need you, we'll be sure to call on you. And that was the last discussion that I had until I was back at the company a while later and found out that 3 or 4 days before the transaction was supposed to be finalized, the target company that they were buying was sued for patent infringement in the United States. The deal fell through, and that was the end of it. Had that lawsuit come 4 days later, the first thing that my client would have acquired would have been a multi-million-dollar lawsuit that it needed to defend. Right? And the problem, of course, was that he wasn't thinking about the fact that when he acquires a product line, he also acquires liability, and he needs to make sure he's got freedom to operate. That's what Steve's going to talk about a little bit later. So, what do you have to ask? What are the questions you need to ask? One, what's driving the company to enter into this transaction? You need to understand, a lawyer or anybody involved in due diligence needs to understand, why is the company doing the deal? What products does the company wish to offer as a result of the deal? What revenue streams are going to come to you? Because you need to make sure those revenue streams are protected. What companies or competitors does the company hope to stop as the result of the deal? Do multiple paths need to be blocked? Sometimes just blocking one path isn't enough. If you have a great block, but a competitor says, great, I like it, I'll just step around it, and goes like this and gets to your revenue stream, the block isn't very helpful. So you need to make sure that all the paths are blocked to achieve your goals. And this is in contrast, and I get a call like this probably 2 or 3 times a year from someone who says, Gershon, just want you to know, company's going to be making an acquisition in the next few months. Term sheet's not quite signed yet, but when it's signed, we want you to do the due diligence. 50 patents involved in the deal. How much is it going to cost? You can't judge how much it's going to cost until you understand what the goals are, how the patents align with those goals, and what type of an analysis needs to be done in order to get there. So, of course, there are lots of different types of IP, and you want to catalog them right from the start so you make sure you're working with the universe. And then what you want to do is after you understand the goals, you want to then compare each asset with the goal. And the reason I do this is a triage method to save you a lot of money. What a lot of companies do is they say, we have 100 patents to look at, we're going to apply equal amount of resources to each patent, and you end up not getting any significant answer. What I suggest you do is you say, let's do a triage. Let's take a look at the patents very quickly, now that you all know how to look at claims, and let's see if the claims look like they've got extra stuff in them that just kill their value. And if they do, let's push those patents aside, and let's get ourselves a small group of patents that really are going to give us value. When the analysts looked at the Google deal, they said there were about 20 patents out of those 17,000 that really conveyed value. I think there are probably more, but that's what people looked at. When Microsoft did the AOL deal, I guarantee you they didn't look at 800 patents. They quickly scanned them, they figured out the ones that looked the most valuable by looking at the claims, and then they focused in hard on those patents that were going to create value, or potentially create value. And you have to do things like look for legal defects in the patents, look at the file history, because it's not just about the claims. The claims is a starting point, but there's a lot of law in the US that says claims that look broad and valuable aren't really that valuable. And I give a lecture here in Israel, I gave it about 4 years ago, called 18 Ways to Kill a US Patent. But here's some quick thoughts on things that you need to think about. We've already talked about extra claim elements in the claims. But what about post-Phillips narrowing? There's a very important case called Phillips where it said that if you write your claims broader than your specification, you're not going to get the broader interpretation of your claims. You're only going to get the narrower interpretation that's in your specification. How many people only give one example and don't say anything more broadly about claim terms? You need to make sure your claim terms are well defined. Divided infringement. How many times do I see method claims where it requires one actor and another actor, and they're both acting in the same claim. Well, guess what? When you write patent claims like that, there's nobody to sue for infringement. Because a fundamental principle of US law is that you have to do everything that's in a claim in order to infringe the claim. So if the claim says you have to do X and Y, a defense to infringement is, I do X, but I don't do Y. The customer does Y at his end. I just sell the product. That's a defense to infringement. You have to make sure that your claims are written with that in mind. Offshore servers are not stopped by method claims. So if you have a method claim that recites a certain function that's performed in Canada, as happened in one of the RIM cases, the court said no infringement. That's not occurring in the United States. Okay? You've got to make sure that your infringement is detectable. A lot of companies focus hard on algorithm claims, and sometimes algorithm claims are important. But ladies and gentlemen, if Google got a patent on its algorithm, how valuable would that be? If somebody were infringing the algorithm that Google uses, no one would ever know. Because you just type in a search term and you get a result back. Right? Sometimes it's better to hold back on those algorithms and keep them as a trade secret. You want to make sure that you are that you don't miss revenue streams. Okay? Medical device companies all the time, they patent a big machine, but they forget that the revenue is really coming from the disposable. So get claims on the disposable, because that's where you're going to get knocked off. You want to look at the prosecution history of your patent, the back and forth that went on between the United States Patent Office and the patent applicant, to make sure that there were no statements made that can limit the scope of the patent. And you want to make sure that you have a good written description in your patent that satisfies the written description requirement in the United States. Then, once you get this narrowed down group of patents, you've separated the wheat from the chaff, and you have 5 or 6 or 8 or 10 or whatever that number is, a smaller group of patents that are likely to give you value, then you do a validity analysis on the patent. Because just because you have a patent doesn't mean it's valid. If there was prior art that came before, anything that came before could potentially affect the validity of your patent. These validity analyses are expensive. You don't want to do them on 100 patents in a portfolio if you can avoid it. But if you can narrow it down to 3 or 4 key patents, it becomes a lot more cost effective. So then you know how to do your validity analysis. And with that, did I make it in time? Barely. Barely. I'll turn the microphone over to Steve O'Connor. Thank you.
All right. Anderson has left me a few minutes in which to speak, which is good. So thank you, and thank you all for coming to listen to us speak to you this evening. So IP due diligence has a bunch of tasks that are associated with it, and generally they fall into 3 categories. And Gerson's covered for us the first category, which focuses on the IP of the target and provides an assessment of the scope, the validity, and enforceability of the target's patents. I'm going to talk next about freedom to operate. But there's a third category that we should at least mention, which is issues pertaining to ownership and transferability of the target's IP. This can be a complicated area, especially in the United States, with our laws regarding co-inventors and joint ownership and the rights that joint owners have vis-a-vis each other. So it's a very fascinating topic, but unfortunately we're not going to talk about it much at all tonight because we simply don't have time, and perhaps another time we can have another lecture specifically about that. If you have questions though, please feel free to ask us after the lecture's over, and we'd be happy to chat with you about that. So freedom to operate, or FTO, the focus now is changing. We're not going to be fixated on the target's IP, we're looking for third-party IP. And a threshold question is, well, why is that so important? If the target has a patent portfolio that's covering the subject matter of the transaction, why do we need to be concerned about the IP that might be owned by others? And the answer to the question requires a look back to the basics of patent law and the understanding of what the patent gives you. And the fundamental right that is provided by a patent is a right to exclude others from practicing your invention. So you can think of patents as basically a form of a wall that you can erect around your invention, and you can keep others away when you've got your patent, but the patent doesn't necessarily give you the right to practice your own invention. And here's a hypothetical. Let's say Company A invents and patents a wireless protocol. Company B becomes aware of the protocol. They have a eureka moment. They come up with their own invention. They invent a cell phone, and they attain a patent on the cell phone that uses the wireless protocol that was invented by Company A. So now, under this situation, each party has a patent. Company A cannot use its own wireless protocol in a cell phone because if it did, it's going to infringe the patent which is owned by Company B. Conversely, Company B cannot make a cell phone using the wireless protocol because if it did so, it's going to infringe the patent which is owned by Company A. So each party has its own IP, yet each party is blocked from marketing a cell phone that makes use of the wireless protocol. This is a situation, it's classic in patent law. It's a blocking patent situation, and one way for these parties to potentially get out of this is with some sort of cross-licensing arrangement. And this is an opportunity for me now to give a plug. As Gerson mentioned, next week our partner Bill Pratt will be here talking about licensing issues. And so if you think you might be in a scenario such as this, Bill is a great person to chat to and can help you get some ideas as to how to get around it. Okay, so the bottom line is having your own patents or acquiring the target's patents doesn't necessarily give you the right to practice the technology you're acquiring. And so the freedom to operate analysis is designed to search for and identify and assess the strength of patents that might prevent you from achieving the full value of the deal that you're contemplating. And one thing to understand about FTO is that it's not a guarantee that you're going to have the ability to do what you want to do in the marketplace. FTO analyses are extremely complicated. They're usually quite vast, and the end result is you've got an assessment of risk, and hopefully if the FTO is done correctly, you reduce that risk to a level which allows you to go forward with the deal, as opposed to getting an absolute guarantee that you're not going to be purchasing a lawsuit as part of the transaction. And the reason why, or the several reasons why, the freedom to operate analysis isn't definitive, part of the problem is there's just so many patents. And you can run searches for technology, and initially the searches, you want to make them broad enough to catch everything that's going to be relevant. You might end up with 1,000 hits, 2,000 hits, 3,000 hits. My second year as an associate at the firm, I had a client who was interested in using liposomes, and a large client with plenty of money to spend, and so I spent one 4th of July weekend analyzing the results of an FTO search on liposomes. We usually put, this is back in the old days when everything was in paper, I had 9 boxes about this wide of United States patents covering liposomes that I had to go through. So part of the problem is the searches end up identifying too many things, and so one way to deal with that is rather than trying to overturn every single rock that's out there, is to instead focus on, focus the FTO analysis rather, on either patents that are key to the technology. In other words, if the transaction covers this subject matter, but there's only a piece of it that's really important to you from your perspective as the suitor, the purchaser, you can focus the FTO analysis on that part of the search. The other way you can narrow down FTO searches is by focusing on patents which are going to be owned by known competitors. In other words, those are the people who are most likely to create headaches for you in the marketplace, assuming the transaction goes forward. And so it's logical to focus the FTO analysis on patents which are owned by competitors. Gerson mentioned triage before, and triage is especially important in FTO analyses. Like I said, you want to be able to search the results that come out and then do a triage and quickly pick out which things are important and which things we can put aside because they don't require any further consideration. So you want to avoid spending too much time analyzing the IP which is owned by non-players or minor players, and focus your attention on the IP which is most likely to be asserted against you. And part of the goal of this is to identify as soon as you can, because due diligence analyses are expensive. They're labor intensive. Oftentimes they're rushed, especially from our perspectives, because the client comes to us rather late in the process. And so you want to try to do things to reduce the cost as much as possible. And one way to do that is to identify as soon as you can any patents held by third parties that might be showstoppers. In other words, these are patents which, if they are valid, they sufficiently reduce the value of the deal such that it's just not worth going forward. And these may be patents which are relevant in particular markets. Let's say the biggest market is going to be the United States, and there's a valid patent in the US that's going to be infringed. You know, that might be a showstopper. Or if it's a product, or it's a patent rather, that's going to be key to the technology which is core of the transaction. For example, you may have a situation where the technology is related to pharmaceuticals. You find a patent that covers the drug itself. Well, that may be a showstopper. Alternatively, if you're interested in purchasing the drug because you want to market it as a cure for heartburn, and somebody has a patent to using the drug to treat high blood pressure, you know, that patent wouldn't be a showstopper because it's not going to significantly impede your market plan. So suppose the FTO search does find a showstopper. What then? Is that the end of the story? Well, not necessarily. That means that you may just have to dig a little deeper in terms of your analysis. You want to consider whether the claim scope leaves you the possibility that you can design around the patent and avoid it by ending up with a product on the market that's not going to be infringing. You might want to assess, in addition to design around possibilities, you know, really get a solid assessment of what potential damages you're facing, but more importantly, whether or not there's a possibility that the patent owner is going to be able to obtain an injunction which might keep you off the market. For example, is the patent owned by a competitor that's got its own product in the marketplace? If so, the likelihood of the patent owner obtaining an injunction is much higher compared to the converse case where the patent owner doesn't have a product on the market. You also want to, assuming you want to consider going forward with the deal, consider whether the patent is strong in terms of its validity or enforceability, you know, or do you have solid arguments? Is there good prior art that's available that you could use to invalidate the patent if indeed the litigation did come? Perhaps the patent, rather than attacking it directly, the way to deal with it is to buy access to it, either through a license or purchasing the patent if it's available. And maybe you can deal with it in a way which just requires adjusting your business plan. You know, perhaps there's a patent in Japan that's relevant and would be infringed if you go forward, but you know, the market in Japan isn't going to be very big, and so while you initially wanted to go into Japan with the product, you can change your mind and decide to skip that and avoid the risk that way. In addition to analyzing the patents that come out of the search, an FTO really requires an understanding of what the patent owners are like. You know, how have they behaved in the past? Some patent owners are very aggressive, others are not. Part of aggressiveness sometimes stems from resources. Patent litigations are very expensive. If the patent is owned by a small company without a lot of resources, and in the past they haven't sued, you may be more comfortable with the fact that even though there's a potential FTO issue, it may not rise to the level of a lawsuit. I've done a lot of work in the past for a client which is active in the agricultural, chemical, and transgenic plant areas, and so one of their primary competitors is Monsanto, and Monsanto sues everybody. So whenever the client was coming to us for an FTO issue, if Monsanto had a patent, that patent was going to get an extensive analysis before the client was going to make a decision as to whether it was going to go forward with the transaction. And then finally, you want to look at see if there's any recent changes that may change the way that a company approaches its patent issues. Perhaps the patent was owned by a small company, no resources, unlikely to sue, and recently it was purchased by Big Pharma, for example. And the Big Pharma company has a history of suing to protect patent rights. Okay, a slight change of perspective now. So, in the world of IP transactions, there are two parties generally. There's suitors or buyers, and targets or sellers. And I'm curious for the people in the audience, if you're affiliated with the company, raise your hand if you're more likely to be on the buyer's side of a transaction. Okay. And how many of you, if you're affiliated with the company, would be more likely to be on the seller's side of a transaction? That's fairly significant. How many would be both? Okay. Okay. There were a couple of hands, maybe a handful of hands, on the buyer's side. Quite a few, 20, 24 hands on the seller's side. And maybe, I think I saw one or two, it's hard to tell with the lights, that might be on either side of the transaction. Okay, well good. I'm glad I asked the question because let's spend a little bit of time talking about IP due diligence from the target's perspective. And the first thing to recognize is nobody's IP is perfect. So there are going to be issues with your patent portfolio. There may be FTO issues. But the issue is, recognize that things aren't perfect. And the big question then is, when are these imperfections detected? Because once the transaction is underway and once the IP due diligence is started, at that point, it's usually too late to fix problems. So as a target, you're better off having somebody come in and resolve any weaknesses in the IP ahead of the transaction getting started. And so the lesson is you want to fix up any particular problems as early as possible. Sometimes that's not as easy as it sounds. From our perspective, it's easy to give the advice. The reality is there are budgetary issues. Fixing things can be expensive. But the tension there is between the expense and getting the technology or the IP that covers the technology in a position where it's scrubbed, and rather looking like that to the suitor, it looks a little nicer. It's more attractive. It has more value. So there's some tension between the expense and when you get this done. But another thing to keep in mind is that if you wait too long sometimes, you get past the point where some things are fixable. And an example is in the United States, you can, after a patent is issued, you can file a reissue application. So if there's some problem with the claims, you can go in and you have an opportunity to fix them. Well, suppose the problem with the claims are they issued but they're too narrow. And we had disclosure that would support broader claims. The claims that we got on the patent, they're okay, but the technology is going off in a direction such that there's a question as to whether the claims are actually covering the technology. And you want to fix that by reissue. Well, in the US, you have to do that by filing the reissue application within 2 years of the patent's issuance. This is called a broadening reissue because you want to broaden the claim scope. So while budgetary issues are important, you also need to be aware that sometimes things need to be fixed sooner rather than later, simply because that's what the law requires. Okay, so this process is basically a strategic analysis of your patent portfolio in advance of the due diligence. And basically you want to review the portfolio, understand the portfolio and its relationship to your business strategy. Gerson mentioned the portfolio going one way and the business going the other way. Well, a lot of times Smaller companies aren't focused on that fact. They're just so busy getting patents and filing applications, they're not sort of taking a step back and saying, okay, the portfolio is moving like this, but really it needs to go like this, and it requires an adjustment. And the sooner you can make the adjustment, the better. So you want to review the claim scope of your issued patents and your pending applications and compare that to what you're doing in terms of product development and R&D. You may find through this process that there are gaps in the protection. And if so, perhaps you need to file new applications to cover the gaps. And then the last point about devising strategies to deal with potential future rule changes, at least in the US, is a very important issue right now because we're in the midst of a lot of rule changes. With the passage of the America Invents Act, we're in the process now of implementing the changes which that change in the law has brought. So we're going from first to invent to first to file. We're having new procedures for challenging patents after they've granted, post-grant cancellation. There's a whole bunch of other changes. In addition to AIA, in my area, which is biotech and pharmaceutical, not too many years ago, we had a large package of legislation passed relating to biosimilars. And so we now have a regime in place, or at least the law is in place. We're still waiting for the regulations that implement it. But we have a regime in place which is supposedly analogous to Hatch-Waxman's small molecules. And under the Biosimilars Act, you need to be ready to think about what's going to qualify as a biosimilar, and what is a generic biologic manufacturer going to do to try and get around my claims to my antibody or therapeutic protein. So there's a lot of changes happening in the US now, and you need to keep on top of them in order to make sure that your portfolio is reflective of the value of the R&D that you're doing in your company. And then there's just basic housekeeping things. Much easier to deal with. Do you have, for all of your patents and applications, have you submitted all the information disclosure statements you need to, disclosing material information to the patent office? Are all the assignments from the inventors recorded at the patent office? This one sometimes gets overlooked. Have all the maintenance fees and annuities been paid? Have all your employees signed over their rights to the invention to you, and can you demonstrate that fact? Do you have policies in place regarding publications, clearance, and laboratory notebook and record retention? Laboratory notebooks and retaining those records, especially important in the US as we are still a first to invent country, and you may need to prove that. And in an IP transaction, the suitor is going to be asking about these things, and it's going to want to know whether those records are available. Why? Because it may need to support the patent if you get into a situation where there's a contest as to who was first to invent. So all of this is in advance of the due diligence, and the whole reason for it is to do, as we say in the US, get your ducks all in a row. In other words, get ready. And the reason for that is your company is going to be more attractive to a suitor if you can show that you're organized, you've considered the issues that the suitor is going to be curious about during the course of the due diligence, and that you have a prudent IP strategy in place. Okay, so that's all in advance. Now we're on the cusp of the deal. So you're to the point where your technology is developed, and you've got somebody out there who's interested in doing a deal with you, so you're a target. Now what? The first thing to do, and it relates to what Gerson said before, is to understand, what's at issue in the transaction. From the suitor's perspective, what is the suitor going to value? And Gerson went through a long list of things that companies are interested in when they want to purchase IP. Which of those things or combination of things is this particular suitor interested in? And how can you position the portfolio to make it more attractive to the suitor with respect to these business goals? And then you also want to pay attention to what the suitor's concerns are. The suitor is going to be concerned about here's what our business plan is. In this transaction, are we getting all the IP rights that we need to protect what we want to do? And then on the flip side, in terms of FTO, they want to be comfortable that they're not buying a lawsuit. And this seems perhaps a little bit like common sense, but from your perspective, you want to make sure you're going to get out of the deal what you want to get out of it. In red, that's probably the most common sense thing is you want to realize the maximum value from the IP that's associated with the transaction. But as a target, you may also have some concerns that the advanced preparation will help you be in a better position to deal with. You're going to be asked for a lot of information, and you want to minimize your potential liability to the suitor. If you say something that is mistaken, or if the suitor really considers it egregious, they might be sufficiently agitated to assert that you deliberately misled them in the transaction, and they may take action against you. As a target, you're going to want to avoid potential third-party claims. For example, was the technology generated in part through a collaboration with another party? And suppose you sell the IP covering that technology as part of a transaction, and the collaborator comes back and says, wait a second, we own part of this. We conceived a part of this invention. Where's our part of this transaction? Doing your advanced study can help you avoid potential third-party claims. And then finally, you just want to be very clear in terms of the limits of what IP is being sold, such that when the transaction is over, your obligations, if they're going to be continuing at all, are clearly defined. Is that my time? Okay. A goal. Well, a due diligence, if you haven't gone through one, it's a very interactive process. And basically the suitor, they want information, right? So they want to know things from you that helps them address the IP issues and the IP analyses they need to do to get comfortable with going forward with the deal and for valuing the deal at here or here, depending on how good the IP is. And so it's an interactive process. They get to ask for things, and you get to supply it. And these things sometimes have different tenors. Sometimes the requests are reasonable. Sometimes the suitor asks for things which are really unreasonable. They seem to be beyond the scope of what they should need to answer the questions they have. But it's important, you want to keep the relationship on the right footing. And so you want to instill trust, and basically you want to be cooperative. Sometimes that's difficult. They ask for a lot. Sometimes they ask for it quickly. So you want to be cooperative, but there are times when you need to push back. And if you have to push back, go ahead and do so, but do so with an explanation why, and perhaps offer alternatives, to what you're being asked of. Because if the suitor distrusts you, it's going to potentially spoil the deal or make it more difficult to complete. One of our partners likes to refer to this exchange, request for information and providing information as the due diligence dance. And ideally it's as graceful as that. As the target, you need to decide what sort of information you're going to provide in response to requests. What documents do you want to make available? You have to be realistic about what is going to need to be given to the suitor. It may be aggravating and difficult sometimes to meet their requests, but you do need to make the effort and realize that probably you're going to need to give up more information than you initially wanted. An online data room, if it's a big transaction, if it's a big transaction requiring a lot of document exchange, and two, if you're in a situation where, if you're in a good situation perhaps, where there are multiple bidders, so there are multiple suitors for the transaction, you might want to consider using a service provider which provides a data room. So basically, copies of the documents are deposited in a central electronic storage place, and you can control access by the suitors to this information. In addition to what to reveal, there's the question of when to reveal it. Some information is not sensitive or confidential at all. Maybe you want to give that first. Some information, it might be confidential. Perhaps you want to hold that for later in the deal to make sure that the suitor is sufficiently invested in the transaction and into its diligence and is still interested in going forward before you turn over the confidential information. And sometimes you just need to say no. For example, if somebody is asking for something that is protected by attorney-client privilege. And it's a fairly common scenario. And it has the potential to take that nice, graceful dance and turn it into a tug of war. Because if you have opinions of counsel, those opinions are subject to attorney-client privilege. And if you turn the opinion over to the third party, to the suitor, you have the potential of waiving that privilege, which means if you ever got into a litigation, the other party in the litigation might be able to request that opinion and see what it says and make use of it to its own advantage in a litigation. And so targets sometimes are faced with the situation where the suitor is asking for the opinion and the target's own counsel is like, no. We wrote that for you, you can't give it up. And so there's the potential for an impasse. You want to think perhaps before you get to this point of ways in which these requests might be met with some alternative fashion. And one way is to, rather than providing the opinion, is to say, okay, you're right, Mr. Suitor, we do have an opinion of counsel. We're not prepared to give it to you, but here is all the factual information which underlies the opinion. You can give it to your IP lawyers, they can assess it, and they can analyze these facts, and we think they'll arrive at a conclusion which indicates that, let's say it's an FTO issue, this third-party patent is not such a big a concern as you think it is. Sometimes those things work, sometimes they don't, and it may require that you consider using an alternative solution, which is perhaps this is a situation where a common interest agreement might make sense. And a common interest agreement is a possibility where the legal interests of the suitor and the target are sufficiently aligned such that they share a common interest, and under that common interest, if you shared the opinion you had with them, arguably it is still protected by privilege. Problem with a common interest agreement is if it gets challenged, ultimately a judge is going to decide whether or not there was indeed a common interest, and it's possible the judge will decide there was not, in which case, having turned over the opinion, you have waived it, and it is now available in the litigation. Okay, so here's one question you're certainly going to be asked by the suitor. Have you done an FTO analysis? And show of hands, how many folks think that that's a good answer? Nobody. Excellent. It's really not, right? So it's a rather, actually it's sort of like this photograph. It's rather unattractive, at least from the suitor's perspective. Remember that the company is going to appear more attractive and the deal is going to appear more attractive to the suitor if you give the impression that you're on top of things. And forging ahead and spending time and effort on R&D to get a product to a point where it's right for a transaction and having not considered FTO at all really doesn't convey that you're a party that has a prudent IP strategy. Okay, suppose you were prudent and you did your own FTO analysis and, well, you found something. Okay. Is that necessarily a bad thing? And the answer is no. Consider these two alternatives. Which is better? Is it better for the suitor to find the FTO problem on its own? Or is it better for you as the target to find the problem and to have a solution before the due diligence starts. You know, under the first scenario, the suitor's going to come to you and say, what about this? This patent is important. It covers the key part of the technology in the deal, and you know, we're facing infringement risk. We're going to value the deal downward 20%. Wouldn't it be better to be in a position to say, yes, we're aware of that patent, we've considered that patent, you might want to have your IP counsel take a look at it because we think there are good arguments for why that patent is either not infringed or is invalid, and so you know, you come out looking a little bit more like this than like this. Okay, swinging back around from the target's perspective to the suitor's, there are some things you want to do with respect to all of the IP, and this is the target's IP. There's that ownership, that third category, and all I'll say about it is, you know, does the target really own the IP it says it owns? That needs to be investigated. We mentioned this before. Are the patents in force? You know, have all the annuities been paid? This is also an FTO issue, and it's probably the first thing that I do if I come across a U.S. patent and an FTO search. The first thing I do is check to see if the patent owner has paid the maintenance fees. Nothing makes clients more upset than if you invest 100 hours of their dollars in your analysis of the validity of the patent you found, only to then learn that, gee, I didn't have to spend 100 hours because the patent's no longer enforced, they haven't been paying the maintenance fees. You want to check to see if a court has either invalidated any patents which are part of the portfolio or narrowed them. There are online litigation databases that should be searched with patent numbers that are key to the transaction. You want to know if the target was ever sued. That's a question that always gets asked, and you at least always get an answer to that one because it's public. You want to find out if any of the target's IP assets were ever challenged in the patent office, or are they subject to a current challenge? You know, in the U.S., that would be re-examination. In the future, it will be post-grant cancellation as well. You know, in Europe, has the patent been subject to an opposition? What was the outcome? These are all things that need to be investigated during the course of the due diligence. And then finally, as we've mentioned, due diligence analyses are expensive. And one of the things that needs to be considered in terms of reining in the scope of the cost is how much can you rein in the scope of the due diligence itself? You know, do you need to check the target's IP in every single country? Well, the answer to that is, you know, how widely you look really depends in part on how central the IP is to the value of the deal. If it's really important, well, perhaps you do want to spend a few extra dollars and look at the strength of patents in markets which might not be the primary markets. On the flip side, in terms of FDO, are you looking at patents just in the US and Europe, worldwide? I don't think anybody looks worldwide that I'm aware of. Some companies tend to focus solely on the US, thinking that if there's a US patent, it's a good assumption that there's going to be a patent elsewhere. I tend to think that might be a little too narrow. And then finally, in terms of the target's IP, again, you know, sometimes you can avoid looking worldwide by just strictly focusing your analysis on key markets, where you're going to have sales, markets where the products are sold, and also in jurisdictions where your competitors are active in manufacturing, because ideally some patents in those situations will be an impediment to the competitors and therefore raise the value of the deal for you. Okay. Well, that is it. Gerson and I would be happy to answer questions on any of these topics. And
if you're interested in the methodology that I suggested on due diligence, I actually wrote an article on it that was published in the National Law Journal a number of years ago, and I'm happy to share it with you. Just give me your business card, write article on the back, and we'll send it to you. Now we're open to questions. Please feel free to ask. We've got about 10 minutes, and then we'll call it an evening. Yes?
So when you do the due diligence, are you more open to willful infringement problems? The fact that you actually know that you're violating somebody as opposed to if you didn't.
Well, one of the issues, the question is, if you do, maybe I should bury my head in the sand, as Steve suggested, because if I don't know of a patent, then nobody's going to find me liable for willful patent infringement. A couple of responses. One, it's getting more and more difficult to find willful infringement now in the U.S. It's a lot more than just knowing. Okay, I wouldn't rely on that, but it's the kind of thing that's it's a much more difficult hurdle to get over. And second of all, if you develop a position of non-infringement, you've got a defense, right? Or a position of invalidity, you have a defense. And the value of your company is going to rest on whether or not you have the freedom to move forward. I think I'd want to know rather than not know. Now, another way to deal with the situation that Steve addressed with the burying the head in the sand. I work with a company here in Israel that's got like this massive prior art library that they haven't developed it, but they know that there are tens of thousands of patents, maybe 10,000 patents out there that are relevant to their technology. There's no way they can do a freedom to operate analysis. So as patents come up along the way, they get cited by the patent offices, we take a look at that, right? But we never did a formal freedom to operate analysis. Now when someone did due diligence on the company a while back, rather than responding to their question, have you done due diligence, and saying, no, we didn't do due diligence, which would have raised a red flag, we just changed the answer slightly. And instead of saying we didn't do due diligence, we said, over the years we've encountered quite a few patents, and we have yet to see a patent that has blocked us from being able to proceed. And that satisfied the suitor. Okay, so there's just a subtlety in the way sometimes you can respond to these questions. Yes?
My question is about the effect of the intended use of the device or technology on the validity and enforceability of the patent. And I refer to your example of the wristwatch. What if a potential infringer claims that they sell an arm watch, and the fact that end users struck to the wrist is not their problem, and if you want, you can sue them directly, but it's not anything that we have a force to see how the market is using our products.
I understand your question. What you're saying is you claim that the question is you claimed it as a wristwatch, and then somebody says, well, people are putting it on their arms. Does it infringe? Listen, there are a lot of tricks to the way. We couldn't fit all the tricks into this lecture. We only scratched the surface. But there are ways that you write claims to get around those types of problems. For example, the band is configured to be placed on the wrist of the wearer. Okay, it's configured. If somebody puts it on their arm, it's still configured to put on the wrist. Okay, so it's still an infringement. Right?
So in other words, if you claim that the intended use of your technology is X, however, it is used by an infringer to serve another use, which is Y. Is your patent still enforceable just because it's a device that is made in the methodology explained in the patent?
Right. So the question is, what if you claim the intended use? And I would argue you need to be very careful with claiming intended uses. You want to try to avoid that. It's not you're mixing method terms into an apparatus claim. And in that situation, the courts have said those types of claims are invalid. I see it all the time. This is not a message that's gotten around, but it should have. There was a case called IDXL Holdings about 7 years ago where a patent was found invalid because it was an apparatus claim and had method recitations in it. You can do the other thing. You have a method with apparatus, but not vice versa. I try to keep those things out of claim. The whole strategy, it's like when I started playing backgammon, I didn't realize even the beginning of it. And then once you understand probabilities of things, you see the game completely differently. And it's the same thing with claims. There are a lot of people who dabble with patent claims. I see poor patent claims all the time. Because there are people who are not focused on what happens in the courts. How are patents invalidated in the courts? So you look at claims much differently than I look at claims. Because I've got, and Steve and Jeff, our heads are packed with all this law in the U.S. as to the nuances of how the claims are enforced. Yes?
In the timepiece example, when you write up the patent, you can say, well, why limit yourself just to a timepiece and have any function wrapped around your wrist? And then
Right.
you can go back to the description
Right.
and expand that.
Right. So the question is, if you could put anything on your wrist, why did I limit those claims to a timepiece? And the thing is that this is really where a lot of patent attorneys struggle. Like, how far do I go with this? Right? You need to talk to the client about it and see where they want to go with it. Is you ask the question: is there anything else that could be strapped on the wrist that's within your invention? And if they say yes, then you work on it. But what happens, and I see a lot with new patent attorneys, is that they get into situations where they start thinking about all these possibilities, and then there's a disconnect between their claims and reality. That's what one of the students said. Someone could put it on their ankle. You missed the ankle. You said the wrist. And I said, yeah, but come on, let's interject some business sense into this. People aren't going to put it on their ankles, okay? So you need to take a step back sometimes, because you can keep cutting back. And if we cut any more out of that claim, there wouldn't have been much left. Now, there's also a problem with that claim. Another thing that we didn't think about was the fact that that claim didn't cover the resellers of watch bands, right? Because it had a timepiece in it. So people, this whole market, there's a huge market of just selling the bands when your band wears out. And my claims didn't cover that because it required the timepiece. So I really needed a claim that also said a band configured to be connected to a timepiece. I don't claim the timepiece directly. I inferentially claim it by saying the band is configured for connection to the timepiece. In a manner configured to enable the band to be more on the wrist, or something like that. You see, and then they get a dependent claim, I had the timepiece. Yes?
Can I go back to this question about intended use in an apparatus claim? Usually when you write claims on apparatus claim, you say an apparatus for ABC comprising of.
Yeah.
And you suggest not to say an apparatus for, so you don't have any.
Well, that's preamble. Anything of first, you never say comprising of, you say comprising colon. But that's called the preamble. The law generally says in the United States that what's in the preamble isn't given significant patentable weight unless you do something later on in the claim that refers back to it and pulls it into the claim.
I'd leave the language out.
You leave it out. Yeah.
You don't need it.
Yes.
Could you please elaborate a bit on the biosimilarity problem?
The question is, could Steve please elaborate on the biosimilarities problem?
We could be here for 2 hours. Can you hear me? I'm not. There are all sorts of problems with the biosimilarities, but from the perspective of developing a portfolio, if you're a biotech company and you are developing an antibody, and now it's not enough to get claims that cover the antibody itself. Under Biosimilars Act, which is part of the reason why we're so anxious to see what the regulations are going to look like in terms of what FDA is going to consider as biosimilar. What the problem is, the basic problem is, anticipating what might fall within the category of biosimilar a priori, and writing the patent application and crafting the claims with sufficient flexibility that you're going to be able to cover the biosimilar. And so one of the things people are looking at is, FDA has issued interim guidelines or temporary guidelines, which are under discussion, and look at the sorts of things that FDA is saying the biosimilar follow-on biologic producer is going to need to show that its product is biosimilar to a reference. All those things. And so all those characteristics are things that you can consider. You have an including in your application, and then crafting into claims. What's the problem in biotech is, unlike mechanical arts, biology is unpredictable. And so once you start trying to broaden things out beyond the actual species that you produce and you exemplify, you start running into tension with written description requirement and enablement. And so from a patentee's perspective, it's a very difficult time. And I can let you
Rachel. And we only have 1 minute left, so this will be the last question. And anybody else who wants to ask questions, feel free to come up. We'll entertain them on a one-on-one basis. Go ahead.
So you said when you're trying to screen a large amount of patents, so you try to listen to the large competitors and see what they're doing. But then how do you follow on patents that are licensed that you don't know it's owned by a small entity, but it's licensed?
So it's a patent which is owned by a non-competitor, but might be licensed to a major competitor unless it's served against you. Good question. If you follow the strategy of strictly looking at competitors only, you might indeed miss that. Hopefully you'll catch it because you've got a second strategy in place, which is, the transaction covers this IP. This part is important to me in terms of what I want to do and get value out of it, and that aspect of it catches that.
Frankly, if you find a patent that's a killer, that looks like it's a 1 or 2 reference, or none of them 1 or 2, but if you find a patent that looks like it's going to create an infringement problem for you, regardless of whether it's big or small, you want to take a look at it because you never know where that patent is going to end up. It can be sold at any time, and you might want to buy it. Right? I had a due diligence, really cool. This is well ended, then we'll take it. But this is like just a wild kind of a scenario where I had a due diligence project where it was a latecomer, it was a medical device company, latecomer to the industry, had no patents, 5 or 6 competitors out there way ahead of me. We did a $500,000 due diligence project. It was huge. We had hundreds and hundreds of references. In the course of this project, we found a patent that was owned by a telecom company. It didn't seem to have anything to do with the technology. But we recognized it was still open. There was still a continuation pending. And the claims weren't that great. But we recognized the way that we could change the claims to cover all the competitors in the market and had a really early priority date. We ended up buying that patent from the telecom company because it was outside of their space and they were looking to sell it anyway for $4,000. We wrote new claims and we put them into the case, and now we had claims with a priority date that were way before everybody else in the industry. And now we had a missile in our arsenal. You want to shoot at us? We're going to shoot back at you. And that bought peace for this company. That's the evening. We'll see you next week.